I'm Jacob Ayler of the Law Office of Riley and Ayler, PC. One thing that's been going on a lot lately with my office, especially with the COVID-19 outbreak, is I've been getting a lot of phone calls from people that have had things in their life that they've been putting off for a while, and now because of the stay-at-home order and the downtime that we're all experiencing, they're using this as a time to address concerns that are easy to put off. One of which is going through the adoption process. As many of you know, there are many different ways to go through an adoption. In the state of Indiana, we have a process where the step parent or a grandparent can actually file a petition with the court to adopt a child whose biological parents either consent to that adoption or are no longer in the picture, and therefore their consent is not required. So I'll talk a little bit about these things. One is, first and foremost, if you are a step parent and to a child, or if you're a biological parent and you have since remarried someone who acts like a parent to your children, you may want to consider the route of going through the adoption process. Far and away, the easiest way is if the other parent who's, for this example, let's say the father has not been around in that child's life. If you can reach out to the biological father and get that individual to consent to the adoption, that is far and away the easiest way to get this done. And what that would include is filing a petition with the court asking that the step parent in this particular situation adopt the child, or it could be a grandmother or another relative, but asking the court to issue an adoption decree. And what that will do is require the petitioner to go through a number of basically routes for the court to look at that person to make sure that the individual who is applying to be the new parent for this child is appropriate. And they do that by a couple of things. First and foremost, you will have to go through a background check. Now, one question I get all the time is, hey, if I have a conviction, am I going to be stopped from adopting this child? And the answer is no. It really comes down to the type of conviction. If you have, a misdemeanor offense or maybe an OWI or something like that from years ago, that's not going to prevent an adoption. The issue is the court just wants to make sure that the individual who is applying to be the father or mother of this child is safe and that they don't have any convictions where children were harmed or anything like that. Another thing that's generally required is what's called a home study, where there's actually a report done where the individual is reviewed and supervised in their parenting skills with the child to make sure that they are appropriate with the child. Now, what is very common is you can actually file a waiver for this type of requirement because for many people, having a child at home with you, if you're a step parent and you've been acting as the father or the mother of that child for years, you really don't need to have a home study at that point. At that point, it's pretty evident that you've been around. The child knows you and you naturally know the child. The court will also need to make sure that this petitioner is aware of the legal responsibilities. What are the legal responsibilities for an adoptive parent? You're going to have to be able to show the court that you're in a position to take care of a child, both physically and financially, and that you are aware of what will happen if something were to upset your marriage or your current relationship. For example, if you adopt a child and you do not, your marriage doesn't work out, well, you're going to be ordered to pay child support on that child as if that child were your own flesh and blood. But on the other hand, you will have rights to visitation or perhaps even custody of that child, which you otherwise would not have had. So both parents need to be aware of that as well. It's also very important that parents who are agreeing to consent to an adoption are aware that they are essentially having their rights terminated as a parent, which means if you sign a consent for an adoption, you don't get to come back 3 months from now and say, hey, I want my child back. Once that's done, and you make that knowing and intentional act of terminating your rights, you have the same legal right to your biological child as the mailman does. You just don't have that right that you otherwise would have when it's been terminated. Now, the other route is if you're in a situation where you would like to adopt a child and the other biological parent is not in agreement with it, then this is what I generally call a contested adoption. And it really kind of cuts into one of two avenues. One is you have to ask yourself, under Indiana law, there are certain situations where consent from the biological parent is not required. So even if that person wants to raise a fuss about the adoption, they don't really have a say-so. Under the statute, there's a long list of things that fall into this category. I'll briefly mention some of the very prominent ones. One is if the individual or the other parent has had a substantial absence in that child's life for greater than a year. So if you have a child with someone and that other parent has been gone for years, has never had any contact with the child, has not had any relationship, and there's not a justifiable reason for that, that could be a situation where their consent is not required, which makes sense. Another opportunity for that is if they have not paid support for the child and have not been supporting the child. That can also be a situation where the consent is not required. There are going to be natural legal reasons as well under the criminal statutes. For instance, if you became pregnant as a result of rape and the father was charged and convicted of rape, then by law, under the statute, there's no consent required. The same thing if the father did not register with the Indiana Putative Father Registry in a timely fashion, then his consent may not be required. So those are just a few of the options where consent would not be required. If consent is required, then you will have to have essentially a trial in front of the court where you will have to put on testimony and evidence to show that it's in the best interest of the child that this adoption proceed forward, and ultimately that the biological parent is an unfit parent. And those are very, very challenging cases. We've handled those, but most of the time it doesn't get that far. So what I would tell everyone is if you're considering going forward with an adoption of a minor child, it's important that you consult an attorney, and you certainly feel free to call our office. The number's 219-866-3435. Right now, because of this coronavirus going on, we've been doing a lot of Zoom meetings, teleconference type of things to keep everybody safe and to kind of practice good social distancing. But I would be more than happy to speak with you about this because it is a process. It's a process where people have a lot of questions. And when you have an attorney that has been through that process numerous times, it'll just make the entire process go a lot smoother. Until next time, I'm Jacob Ayler of the Law Office of Riley & Ayler, PC, and I look forward to hearing from you. Thanks.